Good morning, everyone. I'm going to just give people another minute before we get started. All right, people will still be joining us, but I'm going to go ahead and get started. Happy Thursday morning. I hope it is going to reach 70 degrees wherever you are. A nice little burst of warm weather before it turns cold. I am Liz Wagenseller. I am the Executive Director of the Pennsylvania Office of Open Records. This is our annual training. I became Executive Director in January of this year. I'm the third Executive Director in the agency's history, succeeding the remarkable and amazing Eric Arneson, and before him, Terry Mutchler. So January of 2021 was an unusual time to begin a new job. Fortunately, I became part of a remarkable team who made the transition easy for me, and I am honored to be part of a group of people who are so dedicated to ensuring government is held accountable and providing transparency. Before I get into some items, before I get into the meat of the presentation, a couple housekeeping items. One is this Zoom is going to be recorded and it'll be available eventually on our website if you want to watch it again or share it with people who you thought it might help them. For those of you watching live, the little chat function at the bottom, you can plug in questions at any time. I'm going to attempt to answer all the questions. If for some reason I miss yours or if perhaps it's too complicated, you can always, or if you have questions in the future, email us at openrecords@pa.gov. If you could just please keep your questions on topic and short. If you have longer questions, more detailed, very specific situations, feel free to send us an email, or you can reach us on Twitter. You can reach us in all sorts of ways. All right, so here's the plan for the training. I'm going to begin today with a general update about the Right to Know Law, what's been happening in the last year, what happened during COVID, what's going on today, all of that. And then I'm going to turn it over to George Spees, who's our Chief of Outreach and Training, who will provide an update on the Sunshine Act. Following George, Deputy Director Nathan Byerly will discuss some new case laws, case law that has come out that's very interesting and pertinent. And to wrap things up, I'm going to sort of look at what might be happening with the Right to Know Law in the near future. So with that, I'm going to start my PowerPoint presentation as soon as I can share this screen. Let's see. Give me 1 second. All right, can someone send me a quick note if you can see the screen, the PowerPoint? All right, thank you. All right, so first I'm going to go through a quick overview of the Right to Know Law. This is not meant to be a very basic, a very detailed explanation of everything in the Right to Know Law, but a quick overview to make sure we're on the same page. I'll probably say this a couple of times, but we offer some amazing training sessions every Wednesday at 10 o'clock. You can always join virtually, and one of the ones we do is the basics of the Right to Know Law. But an overview just to go over, make sure we're on the same page. All right, the Right to Know Law, it allows people to request state and local government records. Agencies must respond within 5 business days to the request. Sometimes you can extend that deadline by 30 calendar days, or the requester can grant additional time and tell the agency, hey, yeah, you need a little more time, that's fine. That must be in writing. So when an agency gets a request for records, they can grant that request, they can deny the request, or they can have a combination of granting and denying. If there's any part that's denied, the requester can appeal. Studies have shown that less than 3% of right to know requests are appealed. If you are appealing a right to know request denial, it comes to our office, the Office of Open Records. And we have 30 days in which to determine whether or not we grant the records that were denied or continue what the agency had done and deny them. Again, if there's an agreement with the requester, that can be extended. Once the verdict from the Office of Open Records comes through, whether or not we grant or deny, either side, the agency or the individual can appeal that to court. If it's a county issue, it's Court of Common Pleas. If it's a state issue, it goes to the Commonwealth Court. So a little bit more about our office. We were created by the Right to Know Law. We're independent. We don't answer to the governor. We don't answer to the legislature or the courts. We are an independent agency, and we are considered quasi-judicial. We decide appeals that are filed by people who are denied access to records. We also, according to the Right to Know Law, we have to provide training about the Right to Know Law and the Sunshine Act. And the Sunshine Act may seem like a kind of unique little aspect to what we do, but it is an important part of what we do, and George is going to talk a lot about that. In 2020, we had 2,764 appeals reviewed, which was pretty astounding. We have currently 22 total staff, executive director and a deputy director, 14 attorneys, a chief of outreach and training, and 5 administrative staff. So that is the basics of the office. We also, I just want to mention briefly, we offer a mediation program. This is where if the individual requesting the records and the agency think it might be beneficial to talk through the request rather than go through paperwork, do it via paper. And we found this to be very successful. It can be very beneficial because sometimes things are a little more complicated, and just talking it over like anything in life can help a lot. And if either side can end the mediation at any time, we train mediators and can save time and expense. All right, moving on. As I mentioned, we have trainings, we have weekly virtual trainings, and also if you have a group of people, whether it be a government agency or it might be a group of citizens who would like a little more personalized or custom training, you are welcome to reach out to us, and we do custom trainings all the time virtually. All right, moving on to some more topical current events, right to know requests during the pandemic. As you all remember, when we first heard about this pandemic, it was 2 weeks. We're going to be closed for 2 weeks, but it ended up being much longer than that. So as government agencies across the globe closed and transitioned to remote working, we remained open throughout. There were some false media reports, I think, confusing with government agencies. We never closed. We answered calls, we answered emails, we continued to process requests. So we remained open. But what we did do is, given all the uncertainty and chaos of accessing records and government offices being closed, is we issued indefinite stays, basically a pause, saying, okay, let's let people get things in order. We don't want to deny people an opportunity to access records or agencies to discuss whether or not the records should be accessed for all appeals filed with the OOR from about late March when things started to early April. We just indefinite. And then we switched to 30-day stays in April when things were starting to settle a little bit. And by August of last year, we began issuing stays for only very, very narrow situations. Otherwise, it was business as usual. moving on. So now that things are back to normal, it should be business as usual. There should be, unless a key individual in an agency is ill or quarantining, we believe that there should be no delays in processing right-to-know law requests, including providing the records. This includes no delays to adjust for employees who may be working remotely. If there's a critical staff member who works remotely and critical to getting that record, then they need to come into the office, or you need to find someone who can come into the office. We believe that that is not a reason to delay a response or to delay access to the records. One thing I do want to note is that agencies were very good during the beginning days of things closing and putting up notices on their websites or auto replies to their emails saying, we're closed, we're going to do the best we can, please be patient with us. And we are still seeing here and there some agencies who still have messages saying that they're closed. And I think it's just an oversight, but it's important to get those down, maybe double check, because we don't want people to be confused and think that the office is closed. And okay, now let's talk about the impact beyond just the practical processing, what happened in the world of the right-to-know law. The world was turned upside down with the pandemic, and the right-to-know law experience in Pennsylvania was no exception. It was a remarkable period in terms of increase of requests. As you all know, the pandemic put the decisions of state and local governments in the forefront like never before, resulting in a real increased appetite for information on how policies and decisions were made. I don't think anyone ever saw such close attention being paid to school board, Pennsylvania Department of Health, all sorts of decisions. So it was a really remarkable time in how citizens utilized this amazing law to attempt to find out what specifically is going on. And our office certainly felt the impact of that. Here's a chart that shows the impact, the increase we had. So this is, things were kind of consistent. We had a little, and then this is when the pandemic started hitting, 2019-20, and then this is when it was really going on. This is fiscal years, which are July 1 to June 30th. So we had a 43% growth compared to 4 years ago during the pandemic. It was just amazing. And I will have to commend the team again for how they responded to that and were able to continue to get these appeals out. And I want to note, though, this is just the right-to-know law appeals. These are the ones that we saw. And remember how I mentioned less than 3% of right-to-know law requests are appealed. So you can imagine this percent increase that we saw here was dramatic in some of the agencies. And here's, I'm going to see, probably wondering, well, which agencies saw the biggest increases? Here we go. All right. So the blue is the previous fiscal year. This is the most recent, which is 20 to 21. And as you can see, the biggest increases were in Department of Corrections. Department of Corrections actually saw a decrease, but the biggest ones, Department of Health. Look, 17 requests sort of pre-pandemic appeals to the Department of Health, shot up to over almost 90. A lot of interest there. State Police also had a huge increase, and a big increase also among Department of Labor and Industry had a little bit of increase, but the biggest in terms of state agencies we saw were Department of Health and State Police. See a bunch of questions in the chat. I'm just going to pause for a second and see if George is helping me with that. Great, thanks, George. All right, and then locally, what happens? What happens? Local agencies all saw increases. A lot of agencies saw a big increase in well. The biggest increases were police departments, school districts, and some townships as well. So assuming that the pattern we saw in appeals applies to right-to-know requests, a lot of agencies were dealing with significant increases in right-to-know requests. And then I want to mention just a quick show you of who is making these requests. A lot of the ones we hear about are ones naturally are from the media. So it seems like most of the appeals come perhaps from the media, but that is not the case. The plurality, 43%, come from citizens. Companies are another big portion. Inmates make a lot of requests. Media is just 5%. And then these two little bars here, government officials and lawmakers. We've never included lawmakers before in a pie chart like this, but they started making requests. And government officials also increased. So that was another impact that we saw from the pandemic. All right, now I want to talk about just a sense of some of the stories, things that we learned about because of right to know requests. Here's a three. It just came since July of this year. This one, Department of Labor admits it overcharged unemployed Pennsylvanians millions of dollars. So this media organization accessed emails that showed how the agency discovered this problem and how they dealt with it. And it had been a very delayed in terms of implementing changes. And that is one thing that came out. Another thing, IBM paid PA $33 million to settle lawsuit over jobless benefit computer project. So there had been a lawsuit going on years about IBM and a failed attempt to implement a new computer program, and there was a settlement, and we knew there was a settlement, but both sides had said that they wouldn't say how much the settlement was for unless someone did something like a right to know request. So that came out. And finally, one that you may have heard about is that during the pandemic, they stopped having toll takers, and just if you went through an easy pass, if you went through a turnpike toll, you didn't stop to give money. If you didn't have an easy pass, they just take an image of your license plate and bill you. At least that was the plan. And it didn't work so well. And about half of the people who used that toll by plate, it did not work, and $104 million were missed. So that's another thing that was discovered from a right to know request. And then I just wanted to share a little less serious, at least to some people, but a sort of a unique one that we saw was that this story, kangaroo secret remains safe after Pennsylvania refuses to disclose its location to former Quakertown woman who once owned it. And this is one that actually came to us where a woman's pet kangaroo was taken away from her, and she tried to break into a facility to get the kangaroo. And the Game Commission then took hold of the kangaroo, and she wanted to know where the kangaroo was. And she was denied knowledge of where the kangaroo was being kept because of her, because of the circumstances of how the kangaroo was taken into custody. So that's just a little more unique one. All right. Now I want to talk about a couple unique things that happen as well. One is about acting in bad faith. So one thing that the Right to Know Law says is that agencies need to make a good faith effort to find records or find evidence of records. They need to prove that they actually took the steps to see if records requested existed. And in the law, they can be fined if they do not act in good faith. And it's pretty unusual for a court to find that an agency acted in bad faith, and even more unusual to have significant fees charged, fines and fees charged. And there were two big cases in the last 12 months that did that. Uniontown Newspapers versus Department of Corrections, that was in fall of 2020. They found the Department of Corrections acted in bad faith in searching for responsive records, and they had to pay the newspaper who had made the request over $100,000 in legal fees. And then just recently, the Commonwealth Court found that California University of Pennsylvania had to pay over $14,000 in legal fees and some fines to a newspaper for some frivolous conduct and acting in bad faith for how it handled an open records request. So just a reminder that it's important that you not only take the steps necessary to make sure that records don't exist, but outline that in any appeals that you may be involved in. And then last, before I turn it over, I want to mention one project we did this year. We sampled about 135 agencies at all levels in Pennsylvania and so on to see, okay, how are things going with posting information about the Right to Know Law process for your agency on that agency's website? The Right to Know Law says that if an agency has a website, they must have post some information about the Right to Know Law on that website. There are four things that must be provided. One is contact information for the open records officer for that agency. Two is contact information for our office. Three is a request form, record request form. And fourth, if they do exist, if you have your agency has policies about the Right to Know Law process, you have to post those, but not everyone has those. So we did a quick review. We found that there's some room for improvement. 91% have information on their website, so 91% are complying with the overall requirement. but only 50% have those 3 that everyone must have on their website. So, you know, we encourage, if you are an agency listening, to please make sure you have that information. You can find that report on our website. And we also looked at best practices, things that aren't necessarily required, but are helpful. Because the idea is, if you're a citizen and you've never submitted a right to know law request, and you're trying to figure out, hey, does my township have this or my school district, and you have to fumble around, it really creates a hindrance to doing that. And if you don't provide clear and helpful information as an agency, you may have problems with, in terms of getting them the right information, and it may create more work in the long run. So some best practices, easy to locate. It's nice to have it on a drop-down menu or at the bottom of your homepage, at least something you can search and find if you type in right to know on your website. Comprehensive information for agency open records officers, not just a generic email, but perhaps also their name, phone number. Not everyone likes to email things, to making sure you have good information. A resource account for open records officers. Resource account, that's when instead of saying ewagonstyle at pa.gov, it says open records at pa.gov. That way, if I'm an open records officer and I go on vacation, those emails aren't missed. So it's an account that anyone can access. Printable and electronic request forms for records. Include links to frequently requested information. Police department should include right to know law request information. That's a unique one where if you're a police department, oftentimes you use your county or your township or borough's right to know officer, but you should at least include that information on your website so people looking to know, well, where do I do a right to know request for the police department, where you go. And everything should be provided on one page, one shot, get all the information rather than having different links scattered throughout your website. All right, so that concludes this intro part of our presentation. I'm going to hand it over to George Spees, who is our Chief of Outreach and Training, who's going to talk to you about the Sunshine Act.
Good morning, everyone. Glad to see you. Let's see here. I am seeing how we're working out here. Can someone send me a chat or let me know if you can see the PowerPoint on the screen with agendas at the top? We're kind of working our way through here. Okay, I'm going to assume that it's working since no one's screaming. Unfortunately, trying to find the right screen. Okay, well, let's talk about the Sunshine Act, and I want to focus on the new agenda provisions that were approved that took effect August 29th, earlier this year. Essentially, the requirement is that now, prior to a public meeting, the agency must post an agenda of any issues to be deliberated on or planned official action at least 24 hours prior to that public meeting. Now, when we talk about deliberation, the definition of deliberation basically is any discussion that could lead to a decision on a matter before the board. So this would also include, well, it obviously includes the regular public meetings, but also the special meetings. Now, a regular meeting, those are the ones where, you know, it's like every second Tuesday of the month that you've already advertised in your legal notice with at least 72 hours advance notice. The special meetings are those meetings that come up in addition to the regular meetings, where as far as advance notice, not the agenda, but advance notice needs to be at least 24 hours in advance. So the agenda requirement, and I realize this is confusing throwing all these timeframes out there, has to be at least 24 hours prior to a public meeting, whether that be a regular or special meeting. And the posting needs to take place at least 24 hours prior to that. So what's not included? Well, it would be a work session, and this could be a gathering of the board where there is no deliberation or no decision making. a conference that would be off-site for educational purposes. And then finally, you do not need an agenda for executive sessions. And executive sessions are where the board is meeting outside of public observation to discuss sensitive issues as defined by the Sunshine Act. And then if the agency has a website, the agenda needs to be included on that website as a posting, again, at least 24 hours in advance. So it also needs to be posted at the agency office, the meeting site, and then you need to have agendas available at the meeting itself to distribute to public attendees. Now, a little bit of a caveat with websites. There are a lot of municipalities that have moved away from their own personal websites and are now using other online platforms. So if you have, for instance, a Facebook page as your major means of communicating on social media, that would constitute a website. So we would expect then that your agenda would be posted on the Facebook page. If you have both, then we go back to website only. Okay, if you want to put it on your Facebook page, that's fine, but it does have to be on your website if that's the case. Okay, the new provisions also allow for changing the agenda. So let's walk through a timeline here. Okay, anything prior to 24 hours is fair game. Okay, if you need to add something to your agenda or take something off, you can do that. However, once the 24 hours hits, you can only make de minimis changes that would involve no expenditure of funds and no entering into any contracts. Okay, so that would be from 24 hours prior to up until the meeting is convened. Now, once the meeting is called to order, if there is a need to change the agenda, essentially to add something to it, the board can do that by majority vote. Okay, so they need to take a majority vote that we're going to change the agenda. Then it needs to be explained to the public why they are changing the agenda. And when I say public, that means those people physically present at the meeting, or if there is an online component to the meeting, then that needs to be explained to everyone. Okay, we're changing the agenda and this is why. Then the board can proceed to deliberate and potentially make a decision concerning that item as they would any other item on the agenda. The minutes need to reflect the change that has taken place. And obviously you would do that anyway because it is a matter of official business. And then the previously posted agenda needs to be amended. It needs to be updated to include the new item that was added, and that amended agenda needs to be posted within 24 hours after the meeting has been adjourned. And the posting needs to take place just like you did with the agenda prior to the meeting. So, physical sites, on your website, Facebook page, however you do it before the meeting, you would post the amended agenda afterwards. The law is silent on how long that stays up, but since there's a 24-hour provision prior to the meeting, I think it's reasonable that maybe 24 hours after the meeting would be sufficient. Also, the question has come up, and we've provided guidance on our website. How detailed does our agenda need to be? The law is silent on that. So what we did with our advisory is draw a parallel between an older court case that refers to executive sessions. And it's called the Reading Eagle case. It goes back to, the Reading Eagle is the local newspaper serving Berks County. And the agency was, they took exception to, or I'm sorry, the Reading Eagle took exception to how the Reading City Council was giving very brief explanations as to why they were going into executive session. The court case coming out of Pennsylvania concerning this particular issue referred to language from the Supreme Court of Mississippi, where essentially they use the language that the explanation needs to be sufficiently specific to inform those present that there is in reality a specific discrete matter or area which the board has determined should be discussed. Okay, so that's the language that they used concerning the reasoning to go into executive session. And it expands on that. I'm just kind of paraphrasing here. So our suggestion, our guidance is that for your agenda, look at it from the public's perspective to make a decision on, is it worth my while to attend this meeting tonight? So I look at the agenda, and is the agenda item explained in sufficient detail that I have a reasonable idea what it is they're going to be discussing and voting on? If it doesn't pass that, what we'll call a common sense test, I'd urge the agency to go back and revisit their agenda and perhaps expand on it a little bit. But I think, we're using, in the absence of language in the act itself, and until and if the courts weigh in on this particular matter, I think this is a reasonable explanation that and reasonable guidance that you can use at this point. Okay, so I'm going to try and find the right page here and return to turning this over again to Nathan Byerly, who's going to be talking about.
George,
yes.
Can you hear me? There's
Yes,
some questions in the chat that I think a lot of people have similar questions.
Okay, let me try and find the chat again.
Yeah.
I'm sorry. I'm working here in the training room and I've got two screens up, and
I can just read them to you if that's helpful.
Yeah, why don't you go ahead and do that, Liz?
Okay. In this case, this person says that our school district did not post the agenda for our meeting until 8:37 a.m. this morning. The meeting is tonight. Their excuse was a technical glitch. Does this still fall under the Sunshine Act?
Well, yeah, I think it is a Sunshine Act case. The 24-hour requirement is in the law. There was a similar set of circumstances last year with the Scranton School District, where due to technical issues, their online meeting broke down. So the public wasn't able to observe and participate in what they were doing. And the court basically said, you have to do this meeting over. So, it's while it's up to a judge ultimately to answer your question, I would say that given the circumstances you're giving us here, it could be problematic for the district.
Great. Another one, what about scheduled committee meetings where the issues that may come up before the board council are discussed by a subset of elected officials, but no official action is taken? Does an agenda need to be published for committees?
Our position is that, yes, if the committee is subject to the Sunshine Act, then the agenda requirement is also necessary for that committee.
And then a couple questions about executive sessions. Is there any way to get transparency for executive sessions for school board meetings? Seems like a lot can be discussed behind closed doors. How would we know?
Well, the ultimate answer is no. Executive sessions, the reasons for executive sessions are detailed in the Sunshine Act. They're not required to take minutes, and if they do take minutes, they're not discoverable under the RighttoKnow Law. So if by chance you believe that the executive session provisions are being misused by a district, it would be up to that individual to seek legal relief in their county court. but the burden falls upon the person taking the legal action. So you kind of see the challenge there, that you have to prove the negative, which sometimes is not that easy to do.
If the agenda is posted on Facebook, does it need to stay there, or can it be deleted after the meeting?
Well, the law is silent on that. My recommendation would be to leave it there. There's no harm, no foul with doing that, although there is no requirement that it remain there. We're the office responsible for transparency. So my first question would be, why would you want to take it down? But ultimately it's up to you and how you run your website.
Another question, does the de minimis rule apply to items initiated by the board by majority vote?
Well, the de minimis rule basically says you can't add an item that would involve spending money or entering into a contract. So anything that would qualify as de minimis in that 24-hour window prior to the meeting, I think you'd have to take a look at, how does the board decide what's going to be on the agenda in the first place? I don't think, well, it could not be by majority vote, because that would represent official action, which they can only do in a public setting. So, I think your question is a little bit confusing. It's however they come up with their agenda, they can amend it. It's just only for de minimis items.
Okay. Does a entity need to identify the reason for an executive session at least 24 hours in advance?
I'm sorry, could you repeat that?
Does an agency need to identify the reason for an executive session at least 24 hours in advance?
No, they do not. They can do it immediately before going into executive session. They can do it immediately after coming out of executive session, or they can announce an executive session for a future time.
Is for legal and personnel issues sufficient executive session description?
No, you would need to go into greater detail, and that's a specific example that was challenged in the Reading Eagle case.
Where and how does a citizen initiate a challenge to the executive session item?
Okay, it is a civil matter where, for instance, a school district, you would seek legal relief in your county court of common pleas within 30 days from the alleged violation.
Okay. And here's a little clarity on that previous question. If the board adds something to the agenda by majority vote, can it only be a de minimis item, or can it be anything?
It can be anything once the meeting has started.
Okay. Should the agenda put in the record books be the original with the minutes reflecting the amended agenda, or should the agenda recorded be the, we're gonna have to go back to that one. Diana, we'll get back to you on that one.
Okay, I think it would be the amended agenda, since that would be an accurate reflection of what actually took place at the public meeting.
Okay. All right, I'm going to stop there. If you have more Sunshine Act questions, oh, can a taxpayer bring up issues not on the agenda? And does the board have the ability? Yeah.
Given a reading of the Sunshine Act during the public comment period, it says items that are or may be before the board. That word "may" in there kind of opens it up to items that would not be on the agenda.
Okay. In terms of filing a complaint about Sunshine Act violations, I think that would be a longer discussion. Yeah,
feel free to email the office or call in and ask for me, and we can have a discussion about that.
And then this is one thing we should mention. This is a good question. I'm going to stop here because we have to keep moving. But one last question. Is it acceptable to have online only meetings?
Yeah, our position is that given the language in the Sunshine Act, given the very fact that the legislature passed Act 15 in 2020 during the emergency declaration, And also given comments from legislators during recent public hearings, it's our position, and this advisory is also on our website, that there needs to be a physical component to any public meeting where the public can address their officials in a face-to-face manner.
All right, we're going to move on from there. If we didn't answer your question, we do have a recording and we'll try to get back to you, or you can email us at openrecords@pa.gov.
Thanks, Liz.
Mm-hmm.
All right, so we will move on to our case law update. Hopefully everybody can hear me and this transitioned well. What I'm going to cover in my time is just go over some cases that have come up in the last 2 years. I mean, as we all know, the last 2 years have been very unusual. So sometimes our focus may have been on other things than right-to-know law. And I think it's good to highlight and flag some things that even have come up beyond 2021 and back into 2020 to just bring them to the forefront so that you can, as you see those issues come in, be able to adjust to them and be able to have a resource to go to guide you through whatever case you may and request you may be looking at. I often say, you know, it's not really the issue is not a big issue until it is a big issue and until it's your issue, and then you want to know where to look to try to solve it. So hopefully in covering these cases, which I'm going to do not in super detail, but just in generalities, it will help all of you get a general idea of where to go and general idea of how to handle things as these various issues come up. So the first case that we're going to cover is Chester Water Authority versus the DCED. And in that case, the request was for copies of documents reflecting communications between DCED and some of the consultants and the contractors that they had related to the potential sale of the water authority. And DCED denied the request under section 708B10, which is the internal pre-decisional deliberation exception. It's a mouthful, and if you say it 10 times, it can be a lot of fun. But anyway, one thing I wanted to flag before I jump into the 708B10 analysis is the right-to-know law is not a confidentiality statute. So even though the law says you can withhold records, you don't have to. You still have the ability to exercise your discretion and release those records. And again, as we face, these times of difficulty and discussion and disagreement between people and their government, it is always good to keep in mind that transparency and accountability builds trust. So there may be times to exercise that discretion and release the records may be a better approach than withholding. In any event, in this case, the decision was made to withhold the records under 708B10. And traditionally, the Office of Open Records has held that these records would be exempt as they are communications between and among what we considered internal processes and people within the agency. They were for the review of that agency and making a decision and in coming to that decision. And the Commonwealth Court agreed with us and went even one step further, stressing that the whole point behind 708B10 is to enable agencies to have that candid, frank exchange of ideas and opinions so that everyone can get on the same page with respect to that. The case was appealed to the Pennsylvania Supreme Court, and the Supreme Court disagreed. And it looked at 708B10 and noted that on its face, the statute does not say and does not include consultants and contractors as being in that internal group, so that consultants and contractors are not under the statute internal to the agency. And they said that since they weren't named and the statute requires a narrow construction, they would not be included and able to use that exemption. We have seen this come up since the case was issued roughly a dozen times in different cases. So it comes up a decent amount of time, something you should be aware of in dealing with requests for maybe text messages, emails, maybe even some reports, depending on what communications occur between you and your contractors and consultants. But it's something to keep in mind and a case to read in detail the next time you have a case that involves a request for those type of records. It's always good to touch base with us as well we can give you a copy of that case if you don't have one on hand and ready to go. But something definitely to flag going forward and to check in as you get those requests. And then moving on to bad faith. One of the things that was emphasized in these cases, and as Liz pointed out, was 2 straight years of what I would say are significant rulings. They're the California University of Pennsylvania and the Uniontown. Provide the site to the case I just discussed. Let me just go back and see. 249 Atlantic 3rd, 1106. That's the Chester Water Authority case. Chester Water Authority versus DCED. And moving on back to the bad faith. California University of Pennsylvania versus Bradshaw and the Uniontown case were two situations where courts discussed what constitutes bad faith and gave some guidance on what elements of a good faith search need to be performed by an agency open records officer, or you may hear me refer to them as an ARO. The courts outline what they need to go through to meet the standard of getting a good faith search done. In the California University case, the right to know request was for all records related to donations from a corporation to the university's foundation. The university, giving you a quick overview of the case, I'm not going to get into any of the details there, but the university denied the request, stating, first of all, it didn't have the records, they were records of the foundation, and that regardless, it did not matter who had them because Section 708B13 said that they were exempt as donor information. The Office of Open Records disagreed. We granted the appeal. The university appealed to the Commonwealth Court. The Commonwealth Court affirmed the Office of Open Records. The university then filed a petition for allowance of appeal with the Pennsylvania Supreme Court, which was denied. And then when the university contacted the foundation, they discovered that no such records existed. So at the end of the whole process, the records just didn't exist, which, as you can imagine, the court was not overly happy to find out. They said that this action taken or lack of action taken by the university and the fact that they did not reach out to the foundation first to confirm they had responsive records was bad faith and frivolous conduct. And they further said that in determining whether the foundation had potentially responsive records in its possession, they violated the bad faith clause and should have subsequently, and didn't, excuse me, let me rephrase that. They denied the request without first determining whether the foundation had the responsive records, and then they went ahead and subsequently litigated the denial. They should have reached out first and not just assumed that the records existed and continued with the litigation. And this ties in with the Uniontown newspaper case, which if you remember, I'm not sure that we covered this last year, but we have covered it in trainings. And if you have seen them, you remember that there was a request for documentation of illnesses contracted by inmates and staff members at a specific facility. The court held that DOC acted in bad faith at the request stage because they didn't exercise due diligence, or the ARO failed to act with the diligence required under the statute. Now you ask yourself, well, what is this diligence that was not met? And the court laid it out specifically saying, do not review the request with the Bureau of Health Care Services. So the Bureau within DOC held the records, and the ARO didn't review that request with them to make sure they were on the same page with what was being sought. Then there were assumptions made by the Bureau that there were just medical records requested, so those would be exempt, and they very narrowly interpreted some of the other language within the request. And the ARO relied upon the Bureau, didn't take any additional steps to confirm whether the only records that existed were those that were generated as part of an ongoing investigation, or if they were medical records, or if there were additional records, since the request was broadly worded and was seeking a number of different types of records laid out there. So what do we get from these two cases that can help me? You just repeated, Nathan, a bunch of legal stuff. get practical for me. How does this work? So the elements of a good faith search: advise all custodians of potentially responsive records about the request. So reach out to the people you think or know have those records. This includes third-party contractors. So if you have a contractor or a consultant that may have responsive records, you're going to need to reach out to them as well. Remember that in reaching out to employees, this is going to include personal devices. That kind of goes down a little bit of a different area, but government records on personal devices are still government records and are still subject to the right to know law. Doesn't necessarily mean they're going to be public, but they are subject to the right to know law and need to be reviewed by the ARO, which is the next point. The ARO should obtain and should get a hold of potentially responsive records and have those for his or her review. And then they have the duty and responsibility to review the records and determine whether or not they're public nature. Now, obviously, that's going to be a legal decision and will likely involve working with an agency counsel or a solicitor. There are some requests that may not be required. I know a number of different AROs have different levels of experience. They have different areas of expertise. So legal counsel is not always needed, but can be advised in most situations. If you're unsure or not quite positive that as an employee that the record that you are looking for the ARO is responsive, you should reach out to the ARO. And ARO, you should be alert to and know about employees that may be struggling with whether or not those records are responsive. I mean, we handle this the same way in our office. When we get a right to know request, we as employees go through our records and provide them to the ARO. And there are times the ARO will come back and say, oh, these are not responsive. They don't really have anything to do with the request. It's better to err on the side of caution in these situations and send what you believe is responsive to the ARO. But the employees, contractors should not be the ones deciding if the records fall under an exemption in response to a right to know request. That should be the ARO making that decision. We see this come up from time to time where employees are just not sending the ARO anything and saying, well, it's all covered under a certain exemption, so we're not going to provide any records. That's the ARO's call to make. And then if the requester does not agree with what the ARO has said in the final response, then obviously there is the opportunity for the requester to appeal to the OOR. To the ARO, I would say follow up on inconsistencies, don't make assumptions, follow up on any inaccuracies. You can get a gut feel a lot of times for, I remember this situation coming up related to this request, and there has to be more records than this. Follow up and follow that gut instinct that tells you you don't have all the records, or if they're telling you differing dates, I could say, having done this for a number of years, that many times it has nothing to do with an intent to deceive. There just is a lot of things going on. Somebody may be juggling 2 or 3 different things and miss a group of records or documents, and just be alert for those so that you don't miss those in your search. And I do want to emphasize that these are 2 extreme cases. These are clear-cut failures to search records in an agency's possession and efforts not being made to reasonably follow up with their duties and responsibilities under the right to know law. And I say that because if you are acting in a reasonable manner as an ARO, you will very likely not have the issues that were posed in these cases. And I know sometimes AROs can worry about the impact and their duty of diligence and their duty to go through the records and do a search. But if you are doing a reasonable search and contacting the people that should have the records, then you are on good ground and it will be good standing. The situation the courts are concerned about and the Office of Open Records is concerned about is when no search is done and when records are not reviewed by the ARO and there is not really an effort to follow and comply with the steps that are set forth in the right to know law. And just to run down some additional notes here, you definitely should be searching for records when you get the right to know request. Make sure that they exist or don't exist. Following up, again, directing requests, and these are quotes from the courts, directing requests to other appropriate persons within the agency if they should have the record. Go over the request with them just briefly or send them a copy to make sure you're all on the same page for what records you're looking for. Obviously, the more confusing a request is, the more follow-up that may require for the ARO with employees. And you don't fulfill that obligation just by simply relying on what you're told by others. And I think that's especially true in situations where it doesn't pass the smell test, where somebody tells you, well, I don't have any records, when it's pretty clear they should have some records. It's good to follow up with them just to make sure that indeed, maybe, you know, records have been deleted or discarded, but there should be records there. An agency's failure to locate responsive records until motivated by litigation shows bad faith, meriting consideration by a fact finder for being in bad faith. And again, that's a situation where a right to know request is filed with an agency and they never act on it, and it's a deemed denial, and it comes to the Office of Open Records. And then at that point, then the agency responds and gives the records. If you are consistently as an agency finding yourself providing records after an appeal has been filed, or consistently deemed denying right to know requests, and they end up in being appeals to the Office of Open Records, reevaluate and take a closer look at how you're processing your right to know requests. And it's very good to avoid any type of factual scenario that could put you in any danger of being found in bad faith. And just to clarify,
Nathan,
yes,
Nathan,
go ahead.
before you go on, a couple questions we've gotten. Let me scroll back up. So in the California case, if the records existed and were in the possession of the foundation, would they have needed to been provided by the university to the requester?
The university, what would have happened is the university had a memo of understanding with the foundation. That's typically the way that the foundations are set up. So that they would be considered a third-party contractor. So under 506D, it would be the university's responsibility to get those records, if they'd existed, from the foundation, review them, and then determine whether or not they could be released. So the answer to that in typical attorney fashion is depends, because it would depend on whether or not those records fell under any of the exemptions. But it would be, so if none of the exemptions applied, then yes, they would be released as public to the requester. But I think
the court was trying to say we went through this whole rigmarole and there actually weren't even any records to be discussing. That's sort of what the court was saying.
Right.
Yeah.
Yep. And I have a follow-up slide too, which, you know, is kind of a spoiler alert on that. Oh wait, we'll get to it there.
Okay. And what did this may be going back way too far. What did you say about client privilege? Isn't the client privilege, attorney-client privilege?
The section 708B10 exemption will not apply and be able to be used for consultant or contractor communications. But you're always going to have situations where other exemptions may apply to those records. So if you have a communication between a law firm that you've contracted with and the agency, those aren't going to necessarily be B10 exempt as pre-decisional, but they could be protected under the attorney-client privilege or any other exemptions that might apply to those records.
Is a licensee not the same as a third-party contractor?
We haven't had that one come up yet. That'd be an interesting case.
Sue West, you got us there. All right. Can the OOR declare an agency in bad faith, acting in bad faith?
We have found agencies to be in bad faith.
Okay.
Yes.
And just before you go on, just to tell everybody that yes, the PowerPoint will be made available on our website later today. The recording might take a little bit longer, but certainly the slides you can see later today. All right, Nathan, continue.
And just to clarify too, on the bad faith, we at the Office of Open Records are not permitted to issue any sanctions or fees or fines. That is up to the courts. So that would be in their purview, not ours. Following up with the Uniontown, and I do this with the bad faith, because the bad faith language in the legal world typically means fraud or corruption. And I want to clarify that, and the courts have clarified, that is not what it means in this situation. Bad faith in the right to know context is an abandonment of your responsibilities and your duties under the right to know law, and basically not going and looking for the records and confirming what exemptions apply prior to denying access to those. So the courts have begun really putting more and more of an emphasis on this, and we are trying to do so well at the office, is that you need to go through these records and come up with the exemptions before you deny access. You're supposed to tell the requester that up front and not wait till an appeal is filed with the OOR, or even when it goes to the, if it should go to the courts. And there we go. I was gonna say it froze up there. This is the case that was related to the California University case with the donor information. The court did go on and point out that section 708B13 does not apply to corporations. So, and they did so reasoning that the right to know law uses the term individual rather than person, because a corporation can qualify as a person, but an individual is a natural person and not a corporate entity. So therefore, the B13 language would not apply to corporations. This probably will not come up very much for you as an agency, but if you have corporate donors to your agency for whatever reason, those would be public. And just flagging some cases that have come up in the past. I know we've discussed these in the past, but I think they're good to always keep in mind, because as we continue to advance with technology and videos, especially with this case, videos and cameras are more and more everywhere. Just a reminder that videos are records under the right to know law, and that if you get a request for records under the right to know law for videos, and it is eventually determined that those are public, you will have to turn those over. Those may require some logistical changes based upon the size of the file. Those are considerations to keep in mind. Additionally, if there is information on a video or images that need to be redacted, you could be required to redact those as well. The Supreme Court has found and directed the school district to redact records in a specific case on a school bus video case. So keep that in mind. Logistically, it depends on your agency how many different videos you have or how many requests for videos you may have, what your capabilities are with redaction. My understanding is that it can be relatively simple on YouTube using some of the redaction tools that they have for blurring images, but it's better to be proactively prepared for these issues than to be trying to figure them out when you have deadlines and timeframes that are very tight to get back to requesters with a response. Also, some ones that we've probably covered in the past, and I know we've covered in different trainings, but I want to highlight scores alone do not demonstrate deliberation. So when you think back to that 708B10 exemption with the pre-decisional deliberations, the scoring of like contractors and applicants for different positions, the scores alone will not demonstrate deliberation. The back and forth between you might. The other types of information could potentially do that, but those scores don't alone. Also, when you're regularly releasing a type of information with respect to pre-decisional communications, it's going to be a difficult argument to claim for one specific case that that's internal and confidential all of a sudden. So keep that in mind as well as you determine what information, and take a look at this case if that is an issue that your agency is facing. The Darlington case, just a reminder again that we continue to see the fine tuning, so to speak, of the definition of what an inspection or investigation is. Different statutes require different things for inspections versus investigations and may differentiate between inspections or investigations. This case talks about that and would be good for you to look at if you do get a case for inspection records to determine whether or not they may be exempt under section 708B17, which is the non-criminal investigative exemption. McKelvey versus Department of Health was a request for all the medical marijuana business permit applications that were filed with respect to medical marijuana becoming legal in Pennsylvania. This ties into the good faith search and the bad faith approach to handling records from third parties. In this case, the Department of Health allowed applicants to redact information and allowed those third parties to go in and make the decisions as to what was exempt and what was not. The Department of Health did not weigh in. The court said that that was not acceptable and that Department of Health needed to weigh in on those and to give its view and opinion on what was public and what was not public and what exemptions applied. I'm skipping around there. The court did not find, if I remember correctly, there was no bad faith finding in this case. They just admonished the Department of Health that they should have reviewed those. And there was no monetary damages or anything involved in that case, to my recollection. Again, related to the medical marijuana, just a reminder that failure to submit affidavits and information to the OOR could lead to a situation where the courts don't allow you to put on additional evidence later on. Courts do have de novo review. They can look at all the evidence in its entirety that the OOR collects, and they can add to it and collect their own evidence. However, we've seen more and more courts are not doing this as much as they did when the law was still new in its new stages, and they are not allowing additional evidence to be submitted. So make sure you're getting in proper affidavits and proper evidence to the OOR, which leads me to my last pitch before transitioning back to Liz is please, 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 agencies especially, affidavits are crucial, and quality affidavits are crucial to helping the appeals officer make a determination in these cases. So when you give a conclusory affidavit, it does not give the Office of Open Records any guidance, and those are going to end up being grants because you have not met your burden under the Right to Know law. We offer a webinar training on affidavits, basically breaks down quarterly. If you haven't seen that yet, please feel free to stop in and take a look at that. You can see the slideshows, I believe, are up there as well, explaining and walking you through how to prepare affidavits. Those are crucial to your case. And please make sure you get those in timely, as well. As Liz has laid out, we are facing unprecedented numbers and unprecedented work volume here at the OOR. But thanks all for listening, and I will pass it back to Liz.
All right, I'm back. So as you have seen, it was a big year for the Right to Know law. And the one thing about this law is sort of the party never ends. There's always things going on. And I want to talk about some of the things that are happening going forward. Pending legislation notes, some legislation that is being discussed in the Capitol building. One is vexatious requesters, and I have defined vexatious for many people. And let's see here from current. There we go. One thing, vexatious requesters, what that means. A vexatious requester is considered someone who is has the intent to provoke or irritate an agency. So this legislation has passed in other places, with the idea being that it allows government agencies a process by which they are able to request that someone is deemed vexatious. There's a requester that they think is not utilizing the Right to Know law to find pertinent information or help or information, but rather just trying to annoy the agency. And real quickly, what the legislation as drafted would do is an agency can say, we think this person is vexatious and here's why, here's the evidence. They submit that to our office. And then that individual can provide a defense of their behavior and say why they think they're not vexatious. The Office of Open Records considers both sides and then issues a final order that says, yes, this person is vexatious, or no, they are not. If they are deemed vexatious, then they would not be allowed to submit right to know requests to that agency that submitted this for up to a year. So kind of like a timeout for that person. So that has been, there's a version that has been passed in the Senate, another version in the House. We will see what happens next with that. Another one, commercial requesters. This is something that we do not see quite as often on the appeals process, but we hear a lot from government agencies, particularly local ones, that there are entities that are trying to get real estate information, permit information, all sorts of regulations, that type of thing, that they use and turn around and sell, use as part of their business. Actually, the direct information or that data is used to find potential new customers who need pool service, something like that. This, according to what we've heard, can be a very time-consuming process, and some consider that those type of commercial requests are not within the spirit of the right to know law. And so, as has been done in other states, there is legislation under consideration that would allow individuals to, agencies to charge some labor fees for commercial entities to get that information. So that's being considered. And then one is, there was a ruling about this, I believe 1 or 2 years ago, that dealt with the Pittsburgh's attempt to woo Amazon to have their headquarters in Pittsburgh. Remember all that brouhaha about where Amazon would have their headquarters, and someone wanted to see what Pittsburgh had submitted for, their sort of, here's our spiel as to why Amazon should come to Pittsburgh. And they had claimed this is a trade secret. And also Open Records denied that on appeal, saying that this is not a trade secret, and that the record should be provided. And the courts upheld that government agencies cannot have trade secrets. And so this bill would just put that into law rather than rely on a court case to make it a law. And then the other one that's being discussed is due to the pandemic, there were a lot of requests for some information from the Department of Health, and some people believe that that information was really prevented from coming out. A lot of records were prevented because of a law called the Disease Prevention and Control Law that was written, I believe, in the 50s. And so there's some update to that to hopefully the drafters hope that it would allow more information to come out, aggregate health information. So that's what's coming down the pike in the legislature. Here's some things that we're working on in our office. Electronic docketing system is very exciting. I'm sure everyone is going to be talking about it. This would allow all steps of the appeal process to be conducted on a portal accessed via our website. We're also promulgating our regulations, another thing that's all the buzz on Twitter right now. And then we're also going to rework our website just to make things a little more user-friendly. And if you ever have thoughts or suggestions, on that, if there's something that you find frustrating at our website, openrecords@pa.gov. Couple of things looking forward also, and some of these Nathan had touched upon. I just wanted to give some things that we see going forward that could be improved. Affidavits, submitting conclusory affidavits. That's something that we see often, too often, I would say, in which that's when an agency provides a legal argument or conclusion instead of facts. So these records saying these records are not subject to the right to know law. Well, that's your opinion, that's your argument, but what are the facts? You must explain why the records are not subject. Insufficient search for records, and Nathan touched a lot about that. Just make sure you're proving that you've done a full search. And this is one that one of my things I really hope that can make an impact in terms of those of you who are agencies. If you get a request, there's nothing in the law that says you can't call the requester and say, hey, I'm trying to really understand what you're getting at here, because this seems very broad, or I'm not sure what you're getting at. Having a conversation can illuminate so much and save you, the agency, hours and hours of time, even prevent an appeal if you can just talk through what they're really looking for. You never have to say, requesters out there, why you're making a request, but talking through things can really save everyone quite a lot of time. All right, so I'm gonna look at the chat and see if there's anything that I need to answer. George, anything that I?
No, Liz, I think we're up to date right now.
Okay. In terms of keeping track of the legislation, the pending legislative items, Bill, if you want to reach out to us separately, I can talk to you about that. There is a way to track legislation. It involves getting a lot of emails, but if you are really interested, there's a way to track that. There's also a way to just plug in the build numbers once in a while on a website. So feel free to reach out and I can talk to you about that. Return to the last page. Terry, let's see here. Let's see if it'll let me do that. This is the last page. I'll sit there for just a second while I look to see if there's any other questions that I need to get to. Terry, the one before this one. Okay. Terry, it'll be available on our website, but I will go up. All right, so last thing. So thank you very much for joining us. As we mentioned, this will be, the PowerPoint will be available on the website shortly. The actual recording of this takes just a little more time for us to get up on there. And if you have any questions we haven't answered, if you have questions that come to mind months, weeks, years from now, openrecords@pa.gov, please reach out. And we had a remarkable showing here. Having over almost 300 people join us to talk about open records is a great thing. And I appreciate all of you for joining us, for participating and asking really good questions. And I hope that we see you all here again next year.